Law defense is inconsistent with, among others, the provisions of sections 10 and 12 of the Constitution and is therefore invalid. This was especially so because children may still be effectively disciplined without resorting to moderate and reasonable chastisement, which includes the rod.
A unanimous judgment setting a precedent in the manner children are disciplined. In fact, the biblical credo of spare the rod and spoil the child in a democratic South Africa is now unconstitutional.
It's a victory for all children. It's a landmark moment, and I do think the long, hard work is starting now, because it's really about how we change the debate around parenting of children in the home, that in fact physical punishment doesn't allow children to understand how to behave differently, and I think it's really critical that we start thinking about how we parent in positive ways.
The assault laws apply to any degree. There's no such thing as a light spanking or a light smack. It covers the whole range. The reason being that even those light spankings often lead to more severe forms of violence.
Parents have to now actively try and find positive ways to discipline their children without using violence to communicate with their children. So essentially what we're trying to do now is that we're telling our kids that it's not okay to use violence to communicate, even as a disciplinary tool.
Child rights groups argue that children who are raised by the rod are also likely to be violent adults.
If we just reflect on the violence that's happening in our country and the fact that evidence shows that everything starts with the upbringing of children. And so if we want to change the culture of violence in South Africa, we must begin to understand that the way we parent our children is important to build a new society.
Violence against children leads to violence against women, because children, when they experience violence as a child, they will grow up to either experience violence, so women are more likely to be exposed to violence or attract relationships that are violent, or they are likely to perpetrate violence if they are boys.
The landmark ruling relates to a 2017 case of a father convicted of assaulting his teenage son. In his submission, he argued he was administering moderate and reasonable chastisement under common law. This was upheld by the High Court.
The problematic context of reasonable chastisement is that you as a parent can decide what is reasonable. Now, reasonable is such an arbitrary measure, because what's reasonable for me might not be reasonable for someone else. And in the heat of the moment, what deemed is reasonable could be quite abusive.
Freedom of Religion South Africa could not be reached for comment. Gillian Pillay, SABC News, Johannesburg.